SCOTUS required case presentation. Marbury v. Madison, 1803. Facts. Outgoing President John Adams had issues. Williams Marbury commissioned as Justice of the Peace, but the new Secretary of State James Madison. The holding. The holding was the judicial branch of the government had the power to declare laws by Congress and actions. Chief Justice John Marshall established the principal review. Reasoning. They wanted to know whether the Constitution was the supreme law of the land. It could not be violated by the Supreme Court or an act of Congress. Decision. The decision is about judicial appointments. The court established the principle of judicial review. Dissenting opinion. There was no dissenting opinion in Marbury v. Madison. McCulloch v. Maryland, 1819. Facts. In 1818, the state of Maryland approved legislation to impose taxes on the Second National Bank chartered by Congress. McCulloch refused to pay the taxes imposed by the state, which led to the case. Holding. The holding was that Congress had the power to incorporate the bank and that Maryland could not tax instruments of the national government employed. Reasoning. The court wanted to know if this case about national banks and state taxes was reasonable. The court wanted to know whether Congress had the power to establish a national bank. The argument initiated from McCulloch attorney stating a national bank was necessary and proper for Congress to establish in order to carry out its enumerated powers. Decision. The federal government had the right and power to set up a federal bank and that states did not have the power to tax the federal government. Dissenting opinion. There was no dissenting opinion in the 1819 Supreme Court case. Schenck v. U.S., 1919. Facts. Charles Schenck and Elizabeth Beer declared that the Deers violated the 13th Amendment prohibition against involuntary servitude. The holding. The court ruled that freedom of speech and freedom of the press under the First Amendment could be limited only if the words and the circumstances creates a clear and present danger. Reasoning. Whether the Espionage Act of 1917 violated the First Amendment's free speech clause. Decision. Established that speech that creates a clear and present danger to society should not be protected by the First Amendment. They wanted that sort of speech to be limited or restricted completely. Dissenting opinion. There was no dissenting opinion on the 1919 government case. Brown v. Board of Education. Facts. Before the decision, segregation was present in almost every facet of life, such as public education, public facilities, and housing. The state legislature passed laws that not only encouraged segregation but mandated it. Holding. The Supreme Court ruled that separating children in public schools on the basis of race was unconstitutional. Reasoning. The constitutional question was whether the segregation of children in public schools based on race violated the 14th Amendment guarantee of equal protection. Decision. The case established that race-based school segregation violates the Equal Rights Clause of the United States Constitution. Dissenting opinion. Justice John Marshall quoted, "Our Constitution is colorblind and neither knows nor tolerates classes among citizens." Baker v. Carr, 1962. Facts. Prior to the case, many states had not reportioned their congressional or state legislative district for decades. Holding. Whether SCOTUS had the authority to hear cases about legislative apportionment, the determination of the proportional number of members each member U.S. state sent to the House of Representatives. Reasoning. The case held that redistricting did not raise political questions, allowing federal courts to hear other cases that may violate the Equal Protection Clause of the 14th Amendment. Decision. Enable challenges to congressional redistricting scheme of levering the Equal Protection Clause and the development of the one person, one vote doctrine. Dissenting opinion. Frank further joined Justice Marshall Harlan II dissented at length, arguing that the court had cast aside history and judicial restraint and violated the separation of powers between legislature and courts. Engel v. Vitale, 1962. Facts. Before the case was made, the court had invalidated the early release program for religion instruction for violating the Establishment Clause. Reasoning. The constitutional reason was whether school-sponsored prayer in public schools violated the established clause of the First Amendment. Decision. The case held that school sponsorships of religious activities violated the clause of the U.S. Constitution. Dissenting opinion. The dissenting opinion established clause was only meant for prohibit the establishment of a state-sponsored church, such as the Church of England, and now prohibit all types of government involvement with religion. Gideon v. Wainwright, 1963. Facts. The case was ruled because Clarence Earl Gideon was accused of breaking into a bar in Panama City, Florida. In his trial, he could not afford a lawyer and asked the judge to appoint one for him. Holding. The Constitution requires the states to provide defense attorneys to criminal defendants charged with serious offense who cannot afford them. Reasoning. The case was brought whether states are required under the federal constitution to provide a person charged with a non-capital felony with assistance of counsel if that person cannot afford to hire an attorney. Decision. The Sixth Amendment right to an attorney extends procedural due process protections to felony defendants in state court. Dissenting opinion. Justice Hugo Black dissenting opinion expresses displeasure by writing, "It is not to be thought of in a civil community for a moment that any citizen put in jeopardy of life or liberty should be debarred of counsel because he was too."
Tinker v. Des Moines. In 1965, a group of students in Des Moines, Iowa, wore black armbands to school to protest the Vietnam War. The school suspended them, arguing that the armband would disrupt learning. The students sued, claiming their First Amendment right to free speech was violated. Holding, the Supreme Court ruled in a 7-2 decision that the student suspension was unconstitutional. The students' right to free speech outweighed the school's concerns about potential disruptions. Reasoning. The court held that the students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. As long as the student expression does not disrupt school operations, it is protected under the First Amendment. Decision. The court decided in favor of the students reinforcing the symbolic speech, such as wearing armbands, is protected under the First Amendment even in a school setting. Dissenting opinion. Justices Black and Harlan dissent, arguing that the school had the right to prevent potential disturbances. They believed that the armbands could distract students and disrupt the educational process. New York Times versus U.S. 1969 facts. The New York Times and the Washington Post obtained and published portions of the classified Defense Department report to the U.S. role in Vietnam known as the Pentagon Papers. The Nixon administration sought to prevent further publications, citing national security concerns, and obtained a temporary restraining order against newspapers. The case quickly went to the Supreme Court. Holding, the Supreme Court ruled a 6-3 decision that the government could not prevent the newspapers from publishing the Pentagon Papers, as it would violate the First Amendment. Reasoning, the court emphasized the heavy presumption against prior restraint on speech. The majority argued that the government had not met the high burden of proof required to justify censorship, and that the national security concerns alone were insufficient to override freedom of the press without showing an immediate, inevitable, and direct threat. Decision. The court lifted the restraining orders allowing the New York Times and the Washington Post to resume publications of Pentagon Papers. Dissenting opinion. The dissenting justices argue that the executive branch should have discretion to prevent the publications of sensitive information during times of national security crisis, and that the judiciary was not well equipped to judge the potential harm of releasing classified material. Wisconsin v. Yoder, 1972. Facts. Wisconsin v. Yoder. The state of Wisconsin required children to attend school until age 16. However, 3 Amish parents refused to send their children to high school after 8th grade, arguing that it went against their religious beliefs and would harm their way of life. They were fined for violating a compulsory school attendance law. Holding, the U.S. Supreme Court held that Wisconsin's law requiring compulsory school attendance violated the First Amendment free exercise clause when applied to Amish. Reasoning. The court reasoned that the Amish have a sincere religious belief that the formal high school education conflicts with their way of life and religious values, forcing Amish parents to attend high school would significantly interfere with the free exercise of religion. Decision. The court ruled in favor of Yoder in a 7-0 decision, finding that the state's interest in compulsory education was outweighed by the Amish religious rights. Dissenting opinion. Justice Douglas dissented in part, arguing that the court should also consider the views of the children involved, as they might have personal interest in attending school, even if their parents objected. Sean V. Rano, 1993. North Carolina created a redistricting plan that included an all-ship majority black district to increase black representation in Congress. White voters challenged the plan, arguing it was an unconstitutional racial gerrymander. Holding. The Supreme Court ruled that the bizarrely shaped district could be challenged as a racial gerrymander even though it aimed to increase minority representation. Reasoning. The court reasoned that districts drawn primarily on racial lines are subject to strict scrutiny under the Equal Protection Clause of the 14th Amendment, determined that creating a district solely based on race might violate the rights of voters in racial groups. Decision. The court sent the case back to a lower court to determine if the district could be justified by competing state interests. Dissenting opinion. The dissent argued that the district designed aimed to versify past racial discrimination was a legitimate effort to comply with the Voting Rights Act and didn't violate equal protection since it was intended to benefit, not harm, minority groups. U.S. v. Lopez, 1995. Facts. Alfonso Lopez was a high school student in Texas, was arrested for carrying a concealed handgun at school. He was initially charged under Texas law, but the charges were dropped when federal authorities charged him with violating a Gun-Free School Zone Act of 1990, a federal law that prohibited guns in school zones. Holding. The Supreme Court ruled a 5-4 that the Gun-Free School Zones Act was unconstitutional because Congress had exceeded its authority under the Commerce Clause. Reasoning. The majority argued that possessing a gun in a school zone is not an economic activity that substantially affects interstate commerce. They held that allowing Congress to regulate non-economic activities in the way would give it nearly unlimited power. Decision. The ruling limited Congress use the Commerce Clause, reaffirming the importance of federalism by recognizing the state powers to regulate local issues like a gun control in schools. Dissenting opinion. The dissenting argued that the gun violence near schools could have economic effects by disrupting education, which in turn affects commerce. They believe Congress had a rational basis for concluding that gun possession in a school zone. McDonald v. Chicago, 2010. Facts. Otis McDonald and the other Chicago residents challenged a city's handgun ban, arguing it violated their Second Amendment right to bear arms after the Supreme Court decision in the District of Columbia v. Heller, 2008, recognized an individual right to possess firearms for self-defense. The plaintiffs argue that the right should apply to the states as well through the 14th Amendment. Holding. The Supreme Court held that the Second Amendment right to keep bear arms for self-defense is fully applicable to the states through the 14th Amendment Due Process Clause. Reasoning. The court reasoned that the self-defense is a fundamental right deeply rooted in American history and tradition. Thus, the Second Amendment right to bear arms is fundamental and should apply to state and local governments through incorporations under the Due Process Clause of the 14th Amendment. Decision. The decision was a 5-4 ruling in favor of McDonald, effectively extending the Second Amendment's protection to state and local laws, limiting their ability to restrict individual firearms ownership for self-defense. Dissenting opinion. The dissenting justices argued that the right to bear arms is not a fundamental right applicable to the states and cautioned against incorporating the Second Amendment in a way that limits state and local regulations on firearms, which they viewed as essential for addressing local safety concerns. Citizens United versus FEC, 2010. Facts. Citizens United argued that the Section 203 of BCR 8 violates the First Amendment right to free speech. Holding. The court held a 5-4 that the freedom of speech clause of the First Amendment prohibits the government from restricting independent expenditures for political campaigns by grouping including for-profits, non-profits, organizations, labor unions, as well as other kinds of associations. decision. The majority opinion was written by the moderate Justice Anthony Kennedy, who chose to align with the more conservative justices. The court held that BCRA Section 203 prohibits of all independent political expenditures by corporations and unions violated the First Amendment's protection of free speech. Dissenting opinion with corporations able to spend far more to influence elections than any ordinary citizen, Stevens was concerned that the majority opinion would cause to lose faith in our democracy. Legal entities, corporations, Stevens wrote, are not we the people for whom we constitution was established.